Hello everyone, welcome to Drishti IAS. You're watching the NCERT Foundation series wherein we study the subject of political science or polity with the help of MCQs and PYQs. Now this video is a continuation of the preceding video where we discussed 5 questions and a lot of major concepts. The reason I've divided this video into 2 halves is because I did not want to bombard you with a lot of facts and a lot of concepts and a lot of information. I did not want the video to be too long and hence I did not want it to be too overwhelming for you to grasp. Alright, so let's begin from where we left yesterday. We did 5 questions and today we are going to start with our 6th question. So without further ado, let's plunge in. Question 6 says, in India, the independence of the judiciary is ensured through all of the following except. Now, there are 2 keywords over here, independence and except. Now, see, we discussed 5 questions yesterday wherein we discussed, regarding the functioning of the 3 institutions, the 3 pillars. But yesterday we discussed only 2 of them, which was the legislature as well as the executive. Today, we are going to focus on the third organ, the third pillar of a democracy, which is the judiciary. But let's first try to understand what does independence of judiciary or an independent judiciary means. So, an independent judiciary means that this judiciary is free from influence of the executive. Okay? Or the legislature even, but primarily the executive, which means it is not committed to any political party, it does not play favorites, it is not committed to any ideology and is not going to rule in favor of such an ideology or such a party which carries the ideology that it favors. Independence therefore means non-commitment as well as free from influence. All right, so let's see. The question over here is asking us that the independence of the judiciary is ensured through which of the following except. So it's asking for us to find out the exception to the rule, which means we are assuming that the judiciary is independent and there are certain provisions in the constitution and in our laws that ensures the independence of the judiciary, and we have to find the exception to that. So let's say A is security of tenure for judges. Yes, this is correct. There is a security of tenure for judges, which is 65 years for the Supreme Court judge and 62 years for High Court judge. So the judges cannot be removed from their position before this tenure except through impeachment, and that impeachment is a very difficult process. So this ensures independence. That means the political executives cannot really pressure the judges, okay, and they cannot say, oh, we'll remove you if you do not obey us, if you do not follow what we command. This ensures independence of the judiciary. So this is not an exception. B, salaries charged on the Consolidated Fund of India. Now, when I say that I'm charging the salary on the Consolidated Fund of India, it just means that you cannot vote to cut those salaries. All right? In very simple terms, you cannot really have a vote to cut those salaries. So again, here you cannot pressure the judges to that their salaries would be reduced or their pensions would be reduced because they are charged on the Consolidated Fund of India, which means the judges are going to feel confident. They are going to be independent from the executive. So again, this is not an exception. C, removal of judges by impeachment with 2/3 majority in both houses. Now, this is something called special majority. How judges are impeached. When judges are removed, that process is known as impeachment. Okay. Now, they are removed by a process which is known as special majority. Now, that special majority is very difficult to attain. I'll tell you why. Because when I say that the judges can be removed only by a special majority in both houses of the parliament, so this term special majority means that a majority of the total strength of the house, a majority of the total strength of the house plus a majority of two-thirds of the members present and voting. Okay, this is what you understand by special majority, and both these conditions have to be satisfied in order for an impeachment to take place, and these conditions have to be satisfied in both houses. So for example, 543 is the strength of Lok Sabha. Now what will be the majority? Total strength 272, we discussed. This mark needs to be crossed even when we are discussing the majority in the house in terms of appointing the prime minister. All right, so this plus means and. We are talking about and, it's not or, either this or that. No, we are talking about and. So 272 has to be there. Also, majority of the two-thirds of members present and voting. Now suppose, let's say 480 members are present. Okay, out of these 480, 60 members withheld voting. They say we are not going to vote. They withhold. So how many are remaining? 420 members are remaining. Now what is the two-thirds? If there are 420 members who are going to be present and voting, what is the two-thirds of this? It amounts to 280. It amounts to 280, right? So it has to, so there have to be 272 members and there have to be 280 members. Which is the greater number? 280, right? So on a day where only 480 members of the Lok Sabha are present and out of those only 420 members are voting, we have to ensure 280 yes, 280 votes in favor for a judge to be impeached. And now repeat the same process in case of the other house, which is the Rajya Sabha. So please understand that it's a very, very difficult process, and therefore no judge has been impeached so far. Does this ensure the security of or the independence of judges of the judiciary? Absolutely, because they know that it's not easy to impeach them. They can only be impeached. Removal can be done only in case of proven misdemeanor. Misdemeanor meaning or incapacity. You can only remove the judge on these grounds, either proven misdemeanor, that means there is some misconduct of some kind, or if they are proved to be incapable. Okay, that is only when you can impeach a judge. So of course this is not your correct answer, because it ensures, this hard procedure ensures that the judiciary remains independent of the executive. And finally, option D, Parliament's power to reduce jurisdictions of high courts arbitrarily. Now, arbitrarily is the key word here. Suppose it was true, will it actually undermine independence? Yes, it would undermine the judiciary's independence if Parliament were actually that powerful. So this happens to be our correct answer. Option D, Parliament may actually change jurisdiction. Okay, it may actually happen in some cases. For example, if the territories of the states are being altered, then the jurisdiction may also change, or that may happen. However, please notice the word arbitrarily. It's not arbitrary. It's not easy. The Constitution has not made this easy to happen. So we have our correct answer over here as option number D. Question 7 says the Supreme Court of India keeps a check on arbitrary power of the Parliament in amending the Constitution. Again, focus on the word arbitrary. Arbitrary simply means by my own whim and fancy, however I like it. No, that is now not how things happen in our country, okay? So this is also a PYQ. The basis of this check is, now on what basis does the Supreme Court check the arbitrary power of the Parliament in amending the Constitution? The Parliament can amend a Constitution. That itself is a huge topic in itself. But let's say the Parliament is capable of amending the Constitution, and both the houses, Lok Sabha and Rajya Sabha, have more or less equal powers in this matter. But can they do so arbitrarily? They cannot. Okay? And what is the basis? Why? What is the principle that actually prevents this arbitrary amendment? Let's check. A, rule of law. Rule of law simply means that the same rule or the same law applies to all citizens. Now this has to do more with the application of the same law to everybody and less to do with arbitrary amendment. So this cannot be your correct answer. B, fundamental rights. Again, deals with the rights of the citizens, but not so much with the power of the Parliament to amend any laws or the Constitution. It does not do. Fundamental right is very citizen-centric. But we are talking about amending the Constitution. So, this does not fit as the option. Let's consider option D first. Liberal interpretation. See, there are two types of interpretation. One is the literal or narrow interpretation of any judgment. The other is a liberal interpretation. Okay? So, when I say literal interpretation, you simply have to understand that it will go by the letter and not by the spirit. It will simply go by the law, whether or not that law itself is fair or not. The Supreme Court will not really bother, or any court, if we are taking the literal or the narrow interpretation. So if the law says kill someone as soon as they reach the age of 65 so they did not become a burden on the exchequer of a country, if the law says such, the literal or the narrow interpretation is going to say, okay, well, this is the law and this is how I'm going to interpret it. But a liberal interpretation is going to look at the bigger picture or the bigger context. They may even question the veracity of the law itself. Okay. So here, however, this does not really sit well with amending the Constitution, even though you might think that this is the basis. No, this is not the basis for putting a check on the arbitrary amendment to the Constitution. It is not. Finally, let's look at option C, which is judicial review. Yes. So with the help of judicial review, the power of judicial review, what the Supreme Court can do is that it can declare any amendment which violates the basic structure of the Constitution, the spirit of the Constitution, which violates either the fundamental rights or any spirit of the Constitution in any which way, it can be declared null and void. Okay? The arbitrariness of any amendment can be checked via judicial review. All right? So we have our answer, which is option number C. Let's consider question 8. Consider the following provisions about the appointment of judges in India. So, the first statement says, judges of the Supreme Court are appointed by the President in consultation with the Chief Justice of India. This statement is in fact correct. You ought to know that judges of the Supreme Court are appointed by the President in consultation with the Chief Justice of India. As you can see, there is minimal interference of the executive. Minimal interference, because the Chief Justice's consultation is still required and actually holds a lot of weightage. Second statement says, in practice, senior judges of the Supreme Court play a decisive role in selecting new judges. This is absolutely correct. Like I said, there is minimal interference from the executive, and this actually happens in practice, where the senior judges actually have a lot of say, a lot of weightage in choosing, in selecting new judges. 3. Judges can be removed only through impeachment by a special majority in both houses of the parliament. We've just discussed it a couple of minutes ago. This is absolutely correct, and hence this also forms a very major contributing factor to the independence of the judiciary. So let's see which of these statements or which of these options are correct. A says 1 and 2 only. All 3 are correct. So we'll go directly with option number B. Okay, this is your correct answer. Notice here how all of these 3 statements point to the independence of the judiciary and how they point towards how minimally the executive is involved. Of course, when you go deeper, executive is involved. The Prime Minister is also involved, and the other members, other leaders are also involved in some way or the other. But that is for much later. Okay. However, for now, please understand that the whole point of this concept or this question is to make you understand how independence of the judiciary is ensured. Moving on to question 9, which of the following is not correct regarding public interest litigation? Now let's try to understand what public interest litigation is. If I am wronged, if I am harmed in some way, I can actually knock on the doors of the court. It's very common, right? If I'm aggrieved, if somebody has wronged me, I can actually approach any of the courts to exercise my right to remedy. Now, what about people, let's say, who belong to the marginalized sections, like children, like very poor people, like some very poor women and or laborers? What about these? Can they afford a hefty fee? Can they actually, expect justice in the way as you and I perhaps can? So what about them? So the entire idea is that somebody other than these people can actually approach the courts on their behalf to fight for their rights, okay, or to get their grievances addressed. This is the entire idea of public interest litigation, that the litigation takes place in the interest of the public. Even though I am not the concerned person directly, even though I am not the aggrieved party directly, I can still involve and I can still fight on behalf of other aggrieved parties. All right. So let's see which of them is not correct regarding the PIL. Now, this is something important that you should know, that the only problem with PIL is sometimes that it is known as judicial activism. Okay. Sometimes it is touted as judicial activism because in some cases judges take suo motu cognizance of whatever is happening to these people, to all these marginalized, distressed sections of the society. Judges take what, students? they take suo motu cognizance, which means they take notice on their own without anybody formally bringing a case to their attention. All right, in very simple terms. Now let's see the options. Option A, it allows any citizen to approach courts in cases of public harms. Yes, it does. If there is public harm in any way, any citizen, whether or not that person is directly concerned with that harm or directly concerned with the aggrieved party, whether or not, they can approach the court. B, it has expanded the role of the judiciary in protecting human rights. Absolutely correct. Because now I taught you about suo motu cognizance. Because of this, as well as, of course, because the judiciary can finally also look at issues which generally plague the masses, which may not be brought to their attention normally. Okay, normally I would go to the court with my own complaint. Probably it's a property issue, okay, some sort of an issue, or it's a criminal case. But these are issues that are plaguing the society, plaguing the general masses, majority of the population, and these can be brought to the court's attention, and hence the rights of these people can be addressed. Option C, it allows courts to intervene in cases of corruption and malpractices of officials. Absolutely correct. So if there is some, why should we only limit ourselves to these people who are suffering in this way? People also suffer due to corruption and other malpractices of certain officials. So if that is the concern that is plaguing somebody at that moment, or a group at that moment, or if it's hampering service delivery, then this can also be brought to the court's attention. Absolutely. It requires prior approval of Parliament before being filed. No, it does not require any prior approval. That's the beauty. Okay, it does not require any prior approval from the Parliament, because that way it's going to be very difficult for a common person to approach the court regarding anything. So let's eliminate this. Actually, this happens to be your correct answer, because they're asking not, which is not correct regarding PIL. So option D is incorrect regarding PIL. Let's move on to the 10th question. Consider the following. Cabinet decisions are binding on all ministers, even if they personally disagree. Now, to solve this question, let's try and understand what exactly do you mean by cabinet. So every time a prime minister is appointed by the president, okay, the president also appoints a council of ministers on the advice of the president, on the advice of the prime minister. So along with the PM, and this is Article 75. Okay, Article 75 primarily, that the president appoints the prime minister and the council of ministers on advice of the prime minister. Now, this council of ministers is basically what, as the name suggests, it's a council, it's a group of ministers that aid and assist the prime minister in their affairs. Okay, clear? Now, there is a limit, a statutory limit of 15% to this council of ministers, which means that including the prime minister or the chief minister in case of the state legislative assembly, you can only have 15% of the strength of the house, 15% of the strength of the house as your council of ministers, no more than 15%. So if it's approximately, let's say 80% in case of Lok Sabha, you cannot have 80 members, not 80%. If it's 80 members, then you cannot have more than 80 ministers over here. In case of state legislative assembly, you see the number of seats the assembly has. If it has 400 seats, you say what is 15% of 400 seats? 60, right? So it cannot have more than 60 ministers. The Council of Ministers should only be 60 ministers strong, or in this case, it cannot exceed 80 ministers, and it cannot go below 12 ministers. So you have to have minimum 12 ministers, but maximum you can only have 15% of the total strength as your Council of Ministers. Now again, this Council of Ministers, is further divided into 3 categories: the Cabinet, the Ministers of State, independent charge, and Ministers of State. These are basically attached to the offices of other ministries. Okay. So Cabinet over here is the most important part of the Council of Ministers. It usually consists of, let's say, 50 to 20 important ministers. Now suppose, let's assume that there are 80 ministers in a Council of Ministers. Do you expect that every single decision will be taken by the consensus of those 80 members? It's very difficult to invite them and then create a consensus. So these 15 to 20 important ministers usually meet and decide on important matters, especially important policy matters. Okay, so this happens to be your Cabinet. Then these are Ministers of State. They have independent charge. They're not attached to any other ministries and offices. However, they're only invited to meetings. They only attend those meetings they are invited to. Otherwise, they do not attend Cabinet meetings at all. And finally, there are Ministers of State, which are primarily attached to various departments and ministries. Okay. So, if the Prime Minister resigns, the entire Council of Ministers is deemed to have resigned. This is absolutely true, because the Prime Minister and the Council of Ministers are collectively responsible to the Lok Sabha. Notice the word collectively. So they swim together and they sink together. Okay. So yes, if the Prime Minister resigns, the Council of Ministers is deemed to have resigned. Third, the Council of Ministers is collectively responsible to both the Lok Sabha and the Rajya Sabha. No, only the Lok Sabha. We have discussed this in sufficient detail before. So we'll eliminate this option. Option 1 and option 2 are correct. Of course, we've discussed the Council of Ministers, and fact is that in the Cabinet or in the Council of Ministers, if the decision is finalized by the Cabinet, then the Council of Ministers has to agree to it. All right? Then the Council of Ministers has to agree to it. And sometimes, if the minister does not agree with the Cabinet decision, they usually resign. Now, if one minister resigns, the President or the entire Council of Ministers does not have to resign. However, if the Prime Minister resigns, the Council of Ministers is deemed to have resigned. Now, we can eliminate option statement 3 here, and therefore we have the correct answer, which in this case is option A. Now, before I give you the practice question, let me draw your attention to the NCERT online course for your UPSC foundation. You are currently viewing this series and you realize how important reading the NCERT and understanding the NCERT is to build a solid foundation for your UPSC journey. So, Drishti IAS brings to you the NCERT online course, for which the admissions are now open. You can check the course out. It has 150 plus classes for you, and it has a 2-year course validity. Additionally, the good thing is that if you enroll in this course and visit any of our offline centers to get yourself enrolled in the IAS GS Foundation Classroom course, then you'll receive a full fee waiver equaling the amount that you've paid for the NCERT online course. If you want more details, you can click the link in the description or you can call 87501 87501. It's time for today's practice question. Consider the following statements. 1. The Constitution of India classifies the minister into 4 ranks. Cabinet ministers, ministers of state with independent charge, minister of state and deputy minister. 2. The total number of ministers in the union government, including the prime minister, shall not exceed 15% of the total number of members in the Lok Sabha. Which of the statements given above are correct? A, 1 only, B, 2 only, C, both 1 and 2, and D, neither 1 nor 2. We have discussed this. It's going to be fairly easy for you to solve. If you liked today's session, please like, share, and subscribe. I'm going to come with another topic and more questions once again in the next video. Thanks for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.